Good morning, Mr. Keegan.
Good morning, Chief Justice. May it please the Court, I'm Robert Keegan. I represent the appellant in this case, Southern Union Company, doing business as the New England Gas Company. In 2008, the New England Gas Company requested the recovery of a $4.1 million earnings sharing adjustment pursuant to paragraph 2.10 of a rate settlement agreement that the Department of Public Utilities had approved in a prior proceeding. The adjustment was proposed.
And DPU then went about to interpret
That's correct.
the rate-setting agreement.
That's correct.
Okay, and you're saying that their interpretation was clearly erroneous?
We are.
And why is that?
Well, I would say for three reasons. They failed to analyze the plain language of the agreement. They found that the agreement was ambiguous on the basis of a lack of language as opposed to the plain language contained in the agreement. And having found the agreement to be ambiguous, they then referred to not the language of the agreement again, but rather their precedent on how earnings-sharing mechanisms operate under a performance-based rate-making plan.
Didn't they just interpret the agreement based on their precedent as to how these ESMs were, what they were considered to be and what their purpose was, and they used that precedent to interpret what the agreement meant with respect to
Not all earnings-sharing mechanisms operate the same way.
I understand that, but the Department of Public Utilities concluded that this one should, and that the parties had not agreed otherwise.
But I submit, Your Honor, they cannot interpret that without reference to the plain language of the agreement.
Mr. Keegan, could I ask you this? When one is in this business, namely your client, and you backwards and forwards with, the regulators, do I take it that you would say whatever understanding the department may have had based on the way it did things, out there for the companies that they are regulating, there's not a set practice of doing it. Your client, represented by counsel, not represented by counsel, entered into a contract, reads the contract, this is what the contract says, and doesn't have to refer to practice, may not know about the practice because they were in this for the first time, are they?
Yes, they are. And this is the first earnings-sharing mechanism that's being implemented and applied outside the context of a performance-based rate-making plan. The company was not in a performance-based rate-making plan. And if they actually looked at the language in their performance-based rate-making plans, they would find stunning differences between what's in how the earnings-sharing mechanism works and is implemented under the performance-based rate-making plan from how the plain language of this agreement says it should work. And let me just refer to the plain language of the agreement, where it says that the earnings-sharing mechanism will be implemented through a distribution rate adjustment.
But and it's only for 2 years, right?
Correct.
7 and 8?
Yeah, for 7 and 8. Because the company could file for a rate case under any circumstances as of December 15th, 2008. Under any circumstances.
And
And that was
presumably
part of the agreement. I'm sorry.
That's a part of the agreement, correct.
And your position is a change, the rate-setting change is going forward. Look, I'm showing you I'm losing. So if you don't give me the adjustment I'm looking for, I'm going to lose more in the first 2 or 3 years out.
It's totally gone. And the company in 2007 had a negative 7% return earnings, a negative 7%. That's zero return on invested capital and an operating loss of 7%. It's that type of a revenue deficiency that the agreement says the company will be able to recover only a small portion of in a succeeding year. It says in a succeeding year. It does not say as a permanent, perpetual change to base rates to continue to be recovered ad infinitum until the next rate case. The plain language of the agreement says a distribution rate adjustment to be collected or refunded to customers in the succeeding year. The department's interpreted it as multiple years. They've turned a single into a plural.
And
They're not allowed to add language to the agreement.
Take it, just that the underlying purpose of this was, okay, you're not going to file your $4.1 million I mean, whatever it was, you were going to file this rate base in 2006 or 6, maybe? The one that the agreement supplanted.
We were going to file in the summer of 2006
Right.
a rate case for $7.8 million.
Right, okay, and that's what you didn't do because of this agreement, and this agreement was taking you up to December of '08,
Correct.
and so
So-
you just have, so your point is you need to look at it totally in that, it's self-contained within that period of time.
That's correct. And in two separate provisions that if it's read the way the department reads it, are basically redundant. You have the right to come for a rate case and we'll implement a forward-looking permanent change to those rates. They're interpreting the earning sharing mechanism to do the exact same thing. But in fact, the language of the earning sharing mechanism says no. If you either have a significant under-earnings or over-earnings, those that under or over-earnings will either be refunded to customers or collected from customers in the succeeding year.
I take it, sorry.
No, you,
I take it, Mr. Keegan, that if you applying for a rate change, what you have to I take it, I don't know this, what you have to show is that the deficit that you have experienced, the 7% that you've experienced, is or will likely continue into the succeeding years.
Definitely.
So that it's in that sense, it's forward-looking, and the fact finders have to find that it's not because you paid your CEO a huge bonus or somebody left or you bought something. It's not a one-shot deal. If we keep going in the same way, we're going to have a negative return rate.
And that's exactly the purpose of filing a rate case. It does. The answer to that question does involve, while the department never referred to this in their order below, the allegation that was aggressively argued to the court that this involves the double recovery of the same costs. And
let me ask you that, though. If the ESM was going to, I take it that if it had gone as you are suggesting it should have, you would have recovered in '08 50% of the difference between of the -7 up to 8.
Correct. It still would have been no return on invested capital, but
Okay, you would have recovered that in '08, right?
that's no. I think we would have ended up recovering it in '09. We applied for it in September of '08 because it
Okay.
takes a while after the close of the year
Okay,
to close.
but it's
It's in the
basically,
next year within the meaning of the statute.
Yes,
Okay.
but it's basically covering this deficit in '07.
correct.
So, and '07 is your test year when you do file your rate
Correct.
case. So, and if I'm remembering correctly, part of the agreement is that you don't count
That's
that
exactly
either way. So in that sense, if you're using '07 as your test year, and that, I take it, is the negative 7.58%.
That's when we earned negative 7%.
So you're getting it recognized as it's the test year going forward, but you've also recovered that amount for the year.
That's
I mean-
okay. That's
Well,
okay.
yes, but
That's okay because it doesn't presume that the following year that you will be able to count. I mean, if there's going to be double counting, it'll be if you applied at the end, if you got the rate adjustment. This time you were down, 4%, even though you got the rate adjustment. Maybe then you could go to an earnings sharing mechanism request again, maybe not, maybe you'd get it, maybe not. If any time there's double counting, that's the first time it could occur.
well,
Because in theory, the rate setting
that's correct.
would adjust upwards, and then if you say, well, you didn't adjust enough, and so now I want an earnings shares, earnings sharing. I want to invoke the earnings sharings mechanism.
For the
Then-
next year, for 2008,
Correct. Then you might say, listen, you've had a hearing on your rate setting, and we gave you what we were going to give you. We're not going to allow you to invoke that. I don't know, but that's a more interesting question.
well, not the way the agreement is supposed to work, because we're only recovering 50% of the deficiency for 2007 once.
No, I understand
Okay.
that. I'm simply trying to look at the argument of double dipping.
Yeah.
So
yes.
you use the negative 7%. They let you put your rates up. When the rates are up, it still turns out that you have a negative 3%. If you then try to invoke the earnings sharings mechanism, I suppose the department could come back and say, look, you told us what you were going to do. We gave you the best we could give you. Now you can't have the earnings share, but it doesn't involve this
That
situation.
question could arise, but it's not involved
Sure.
here. Certainly, the process of setting base rates or new base rates is prospective, and it's designed to establish rates that will provide a stream of revenues in the future, designed to recover the cost the company will incur in the future. Now, this court is very familiar with the use of a test year, where you look at a historic 12-month period, you take the closed costs, you adjust them for known and measurable changes, and you put them into effect, adjusted for inflation again, as a proxy for what the level of expenses were, so that you get the level of revenues that will cover those expenses. It has nothing to do with actually recovering the costs from 2007. The earnings sharing adjustment, on the other hand, goes back and is designed to establish a stream of revenues to offset a portion of the revenue deficiency or the earnings deficiency.
I should know this. When did the ESM come into being?
Well, this ESM, and I have to say, an earnings sharing mechanism is a general concept. Can be used in PBR proceedings for a certain purpose. It's used in this agreement for a specific purpose. It came into effect for the purposes of this agreement when we filed the agreement in the summer of 2007. PBRs, it's been in, well, I think there are 3 PBRs that the department referred to, and it's been in there, I would say, since 2005.
And the ESM was only intended to last 2 years in this case, 2007, 2008?
That's correct. That's correct. It was filed on
2006.
And I saw this mistake in the brief. It was actually filed in the summer of 2007, the agreement. Was filed in the summer of 2007.
Not part of the 2006 stipulation?
Well, we had intended to file a rate case in the summer of 2006, but went into negotiations with the Attorney General's office and other parties. That took a year. The actual settlement agreement did not get filed until the summer of 2007, for effect over the next really 18 months, because we would be allowed to file a new rate case under any circumstances, regardless of our earnings, as of December 15th, 2008.
So there would be no overlap between the ESM and the new rate, the new base rate?
Well, I would submit there's no overlap anyway, because when you set a new base rate going forward, that base rate is designed to cover future costs.
But going forward from 2008?
No, it goes from 2009.
Or from 2009, after the ESM would have expired?
There would be no more earnings sharing mechanism, although we might still be recovering part of the earnings sharing deficiency from 2007
But
at the same time.
Does the negative 7% is the ROE? Is that right?
That's correct, Your Honor.
Does that negative 7%, when you're using 2007 as your test year for your rate case, your base rate case, does that negative 7% get factored in there somehow?
Well, it doesn't. It really doesn't. Only to this extent. The department takes a look at those expenses and looks at
Are those reasonable? Are those
reasonable expenses
Okay.
prudently incurred and directed toward providing service to customers with used and useful plant, and they take a look at those expenses and they ratchet them up for known and measurable changes in inflation to say, okay, if the company's expenses are at this proxy level in the future, then what do our rates need to be going forward?
I take it that they would do precisely the same thing if the shoe was on the other foot, that if you had an ROE of 15% plus or 20% plus, they would be in their rate setting like crazy, and they would not be ignoring the ESM, I take it.
I can guarantee we would be refunding those excess earnings from 2007
And
as a one-time refund.
And they would be setting new rates going forward.
No, they wouldn't be part of the
No,
new
they
rates
would not
going
set
forward.
new rates going forward until we filed a rate case, although the
Right.
settlement did allow the Attorney General to call the company in for a rate case under those circumstances.
But that return would not be part, even if it would get refunded, but it wouldn't be part of looking at going forward.
It would
for your
not. It would
2000.
not factor into the setting of rates going
Right,
forward.
right.
This is a one-time recovery of a 50% amount of an earnings deficiency. And
Mr. Keegan, let me just ask you, they rely on paragraph 3.8, the one that says, you know, you can't recover costs that are collected by the company more than once.
yes, Your Honor.
What do you say?
Well, I think that's exactly right, and that's not what we're doing here. Base rates are recovering future expenses. They're not going back and recovering 2007 expenses. The same costs are not being recovered under the same two mechanisms. And I would just say that if you look at the exclusion, which arose earlier, it would create an absurd result under the way the department has interpreted the agreement. Because if in fact it's meant to be redundant with paragraph 2.11 in a permanent, ongoing, pancaking change to base rates, and you're going to exclude that amount from future earnings sharing calculations, then you're layering on, under the department's interpretation, year after year, successive earnings sharing adjustments, while looking at the exclusion says when you make that calculation, you have to take those revenues out. And so it would result basically in the company being able to earn excessive earnings, and since you're removing those revenues from the calculation, you're still getting another earnings sharing adjustment. It just doesn't work under the way the department has interpreted it.
Was your base rate application seeking to establish a base rate based upon the actual earnings of 2007 and 2008, or based upon the earnings of 2007 and 2008 as affected by the ESM?
You'd say neither, correct?
I would say neither, right.
Again,
it's the process of setting new rates is entirely forward-looking. It really does not look back, except for looking at the company's operations to kind of see what's the right level of expenses to base these rates on for the future.
But you're going to base it on what happened in 2007 and 2008, or as it actually occurred, or 2007 and 2008 as affected by the ESM?
No, not as affected by the ESM. Right. Looking at what the actual operations were, prudently incurred expenses to provide the level of service necessary to customers. That's what they're trying to have rates reflect.
Thank you, Mr. Keegan.
Thank you very much, Ewan.
Ms. Shin. Good morning.
Good morning, Your Honors. May it please the Court. The inherent underlying flaw in all of the company's arguments is that they all assume that there is some mechanism through which a utility can retroactively recover past under earnings from its ratepayers.
Isn't that exactly what the ESM is all about? We've lost more money than the agreement specifically says if we lose more money than X, or if we make less money than X, we get to share the deficiency. Isn't that exactly what this agreement provides for?
It provides, Your Honor, and the way that ESMs have been consistently interpreted in the past is it provides for a sharing going forward.
Consistently interpreted in what circumstances?
I'm sorry, Your Honor?
In what circumstances?
Sharing going forward, in what circumstances?
I mean, this is a one-year deal, right? This ESM mechanism is for 1 year. You've got to do it in the next year.
You don't have to do it in the next year, only if there is an additional deficiency in the following year, or if there are over-earnings and the AG can come in, but the company would have to apply the following year based on a deficiency in year 2008.
But under the plain language of the ESM, they were only trying to recover losses for 2007 and 2008, weren't they?
They were only trying to recover losses for 2007, and the department's position is that it was adequately compensated for those costs because it received the new base rates.
But the new base rates don't deal with 2007. So that there's maybe an oxymoron. There's an internal inconsistency with you saying they were only trying to recover for 2007, and they got it in the new base rates, but the new base rates are going forward. They don't deal with 2007.
They are going forward. It takes into account what happened in 2007. And the flaw in what the company is arguing is that it's assuming that even though it's now gotten just and reasonable rates that will protect it adequately going forward, it's assuming that it's now also entitled to be compensated for the actual costs that it incurred.
It's not also, what's the purpose of having two mechanisms?
Okay, so the two mechanisms are not redundant, Your Honor. They have different thresholds, and the advantage of going under the ESM provision is that you don't have to go through the full-fledged base rate proceeding, and so you can get very quick relief, although it's not complete relief. In very rough terms, you would get 50% of the deficiency.
But if they, when did they file the base rate case?
They did that first, right?
They did that first.
Oh, no, I don't mean 2006. I mean after you signed the ESM and then the one that was going to go forward as of 2009. When was that filed?
That was filed in July of 2008.
Okay. Let's say they had waited 6 months and filed it on December 16th, 2008, which, so it wasn't, they could do that under the agreement, correct?
Correct.
If they had done that, they would be entitled under the ESM, wouldn't they, to recover the difference between 8% and minus 7%?
If the ESM rate
50%
proceeding had come first, the company would have been entitled to recover half of that deficiency. If they then followed up with the base rate proceeding
in 2009,
right, the base rate proceeding would have to take into account the adjustment that the company received under the ESM.
But it says specifically that it won't do that. Isn't there language in that agreement that it's not going to be counted in?
Only if the company filed in successive years for an ESM adjustment. Not the base rate proceeding does not exclude the prior year's adjustment.
Well, the last sentence that Mr. Keegan mentioned in oral argument was that the company that the base rate going forward was not going to be impacted by anything they recovered under the ESM.
That's not true, Your Honor. The sentence about excluding the prior year adjustment appears in paragraph 210.
Yes, I understand that, but surely the issue here is when the department is setting the base rate, right? The department is trying to figure out in very crude terms, are the expenses of this utility company reasonable and appropriately chargeable to consumers, right? I mean,
Right.
The one I keep using is CEO compensation because it's so easy. Right?
Right.
The CEO leaves, the new CEO comes in and wants a compensation packet which is 10 times. And so all of a sudden, they come in for the new base rate, and you look at this and you say, no way. We're not going to do it. That's what you're looking at. You're not looking at whether in 2007 there was or wasn't an adjustment because of the...
You're definitely looking at the results of 2007. You're looking at past results.
No, but I'm saying you're not looking at the results of 2007 as adjusted by an earnings sharing mechanism, because either that did or didn't occur. And even if it did occur, you're going to look at that compensation packet and you're going to say, I'm sorry, I'm not adjusting your base rate. Not because of the ESM, but because you're paying this person too much money.
That's true, Your Honor, but my point is, as a technical matter, if the ESM adjustment had come first, then once the base rate proceeding goes forward, you look at what happened in the entire year, and that would have to take into account this upward adjustment that they received.
Why would it do that? I mean, just conceptually, I'm having a difficult time because I've got a one-shot partial repayment for my lost, for my negative rate of return. That's all I've got. But my operating costs haven't changed. My payroll hasn't changed. Nothing else has changed. Nothing else has changed. Isn't that what I'm looking at from the department's point of view to see whether those are reasonable? I don't mind whether you got a little, 50% of what your negative rate of return was. I'm looking to going forward, are these ongoing operating costs such that if I don't change the base rate, I'm going to essentially put this company out of business?
You would say you have to weigh in the revenues as well, right?
But these are technically not revenues.
They're technically not revenues, but that argument presupposes that the purpose of the ESM is to retroactively recover these costs. And the department's interpretation is they're not. Just like a base rate proceeding is a proxy for determining future performance, The ESM is also a rougher proxy in terms of the deficiency is designed to measure how much do we have to increase these rates in order for the company to stabilize going forward.
Why would you do that when the amount is set? There's a max. I mean, in other words, you're saying to me, you know, I do a little test case, but there's a maximum beyond which you can't go, right, under the ESM mechanism.
There is, and that's the maximum, the discrete amount is intended to determine how much the base rates must be increased in order to stabilize the company going forward. And
it's an evidentiary matter. That may be the case.
no,
But that's for you to determine. You're the one who sets the base rate, not the company.
Right.
You set the base rate, so if you want to say, well, we gave them a shot of $2 million and using the ESM mechanism or whatever it is, invoking the ESM mechanism, but that's not going to be repeated, so we're going to discount that or not discount that.
my point is, Your Honor, is that the way that ESMs in operation have always been interpreted is prospective adjustments to base rates. So the company does not contend that they could file this base rate proceeding, get a prospective adjustment, and then get another prospective adjustment on top of that through the ESM provision.
Is it your position that if the shoe were on the other foot and it turned out that the base rate for 2007 was too high and they ended up with a 20% rate of return, that you would not seek under 210 to get half of the difference between 20% and 12%? You would say that's to be addressed with regard to future base rate proceedings?
If there were over earnings, the Attorney General could apply under 210 for an ESM adjustment, and that would occur
Under 2007.
prospectively. Yes. But
And could they also then, under 211,
Right.
seek a new base rate?
And they probably could not do that because then this would be the same
Unless you
situation as
authorized
here.
to say so, I wouldn't concede that.
Well, I mean, that's the way you're suggesting, and that the DPU, and I can read it, they've interpreted these to be options directed at essentially stabilizing income during this period of time to the extent there's some major change. So you would suggest it works for both. The Attorney General can exercise its rights or the public's rights under 210 or 211 if the earnings are too high, and comparably the company can exercise their rights under 210 or 211 if their earnings are too low. But they can't do both. Is that your position?
That's my position, Your Honor. And
Where in the language of 210 does it say that? Because first of all, we're looking at a contract. Agreed?
I'm sorry?
We're looking at a contract.
Yes.
So unless it's ambiguous, we don't get to look at what you think it should mean. Agreed?
But you say it's ambiguous.
It is ambiguous,
Oh,
yes.
but if it's not ambiguous,
Certain, sure.
okay. So tell me where in 210 it says that.
210 doesn't say one way or the other, and as the company conceded below, paragraph 210 does not expressly state how the ESM should be recovered. It doesn't state that it can be recovered retroactively on a one-time basis. And because it was ambiguous, the department was correct to follow its usual, very well-established presumption against retroactive rate making and interpret the ESM as a means to stabilize earnings going forward. And I want to emphasize, this is not your ordinary contract. This was an agreement that had to be filed with and approved by the department. The department held 2 public hearings. It had the opportunity to hear from both the public and the parties, and it only approved the agreement after finding that it would be consistent with the public interest and it would result in just and reasonable rates.
How does that make a difference?
It makes a difference, Your Honor, because it changes the scope, how this court has to review the agreement. It has to be looked at through the lens of the court has to consider not only
The
what
department approved this agreement as written.
it did. And so the court has to consider not only what was the party's intent, but you have to look at whether that intent was adequately communicated both to the public and to the department.
I have to say, I read 210.
Yes.
I read 210, and it just, it lays out the 50-50, and then it says for any year in which the return on
Equity.
on equity is outside this bandwidth, i.e. some past year, because you don't know until you've got your final figures in, the 50% portion that is to be paid to or collected from customers would be made through distribution rate adjustments in the succeeding year.
Right, so the rate adjustments are implemented in the succeeding year, but it doesn't say whether or not that's through base rates or through the local distribution adjustment factor, which is
It's
what the
through
company argues.
distribution rate adjustments. It says through
Which does not have a defined.
It doesn't define. That doesn't specify how the adjustments are to be made. Distribution rate is a general term that can apply to both base rates and to the local distribution adjustment factor.
But they were only looking for the ESM to apply to 1 year, and then they were going to then they asked for a base rate to change prospectively after that, weren't they?
Yes, and again,
so where's the ambiguity?
I actually failed to see the ambiguity, and all you've told me about hearings and so on and so forth says this wasn't some off the rack. This was carefully tailored to a known situation. It said, for this year we do that, and then for the 2007 and 2008 as tested on a calendar, should the company's then return on equity drop 3%, the settling parties agree that has the right to file.
and these two provisions cannot operate in tandem because of the very nature of how an ESM provision operates. It operates prospectively, which means paragraph 3.8 then prevents the company from proceeding under both provisions at the same time.
It doesn't operate prospectively. It simply tells me when my customers are going to have to pay up, and there's no other time that the customers have to pay up because, presumably, you've got the 1 year period. In other words, do you spread it out over a year, or do you add it to something else?
The department has consistently interpreted an ESM to operate prospectively. If it goes retroactively in through the LDAF, which is what the company argues, that is retroactive rate making. And the company is asking this court to make several very large assumptions. It's asking the court to assume, first, that the department has the authority to allow retroactive rate making through settlement. It's asking the court to assume the parties intended for this agreement to allow for retroactive rate making. It's asking it to assume that the retroactive rates can be...
You're just putting the name on the door. It's not retroactive. You say in the next year or in this following year or in whatever it is, this is what we're going to do. We're going to check to see what comes in. This is signed when? June 8, 2007. We're going to figure... Presumably you don't have the final figures, correct? I assume.
Yes, correct.
So it just says, when we get the final figures, this is how we're going to deal with the situation.
It's not simply a name on the door, Your Honor. The fundamental policy that bars retroactive rate making prevents this amount from being collected through the local distribution adjustment factor.
Why did the commissioner approve this, approve the ESM? It strikes me that when you read it, it has to be applied to the previous year, and the adjustments will be made on bills for the upcoming year.
It's applied
it says that.
to the previous year in the sense that you look at what was the deficiency that the company incurred in the previous year in 2007. Then the department calculates what amount do I need to bring the company up to the threshold, which is 8%. You divide that by half, and then that is applied as a percentage increase across the board.
Let me try one other way. The company, absent a settlement agreement, just regular, they're doing business, right? They can apply for a change in rates, right? I mean, I don't know whether you can't do it every year. I have no idea, Mr. Keegan, but maybe you can do it every 2 years or 3 years or something or other, right? I'm just telling you, I'm just reading the language, right? I'm just reading the language. I'm not reading what's in your drafter's head. I'm just reading the language. And the language says 210 deals with a particular thing. Then it goes very specifically. This is a June 2007 agreement, and it says, we can do any adjustment, shall be subject to investigation. You can come in and do this. And then 211 comes along, and it seems to me that 211 is saying, you know what? Even if you go under 210, you can go under 211. Otherwise, why on earth is the department granting the company the right, quote unquote, to file a distribution-based rate case?
And the department's reading of that, Your Honor, is that you can file an ESM petition under 210 if you meet the threshold, which is 8%. If something goes even more horribly wrong and you fall below 7%, you now have the right to go in and get your rates completely redone, which is more complete relief than what 210 provides, which is roughly 50%.
But I read that to say, here's the ESM, and that's not going to bar you from coming in to do a base rate. It seems to me that's why you have 210 and then you 211. But I'm going to agree that you have a right to file a distribution rate case.
Paragraph 3.8 prohibits the company from proceeding double collecting under both of these provisions. And the only reasonable...
It doesn't say that. It says it prevents double costs. And once you characterize it, then paragraph 310 clicks in. But it's only...
My position, Your Honor, is that at the time that this settlement agreement was executed, the only reasonable reading of paragraph 210 is that the adjustments have to be made going forward. And that's because the department cannot set retroactive rates. It's consistently interpreted ESMs to be made going forward, and that's why 3.8 operates here, is if both provisions are intended to be prospective increases, then the company can't proceed under both. And this isn't just putting a name on it, but the money has to be collected somewhere. And we know it can't be base rates, because base rates always operate prospectively, and this is precisely why the only argument that the company raised before the department is, oh, we can collect this through the local distribution adjustment factor, which is inherently retroactive because it's recovering on dollar-for-dollar basis actual costs that were incurred in a past year. In order to recover something through the LDAF, you have to set it forth in the tariff, and that is required by law. The purpose is to put the public on notice that we're going to start charging you for these things in the tariff. In the agreement, the parties specified pensions and post-retirement benefits will be recovered through the LDAF, and they amended their tariff to allow for recovery through the LDAF. There's no mention of earnings sharing, and it's simply inconceivable that they would see fit to include items like pensions, which are traditionally recovered through the LDAF because they're volatile costs. They'd see fit to include that in the amended tariff, but not this earnings sharing when that would really be a drastic change from basic rate-making principles. They'd be getting a return on equity retroactive. I'm sorry.
Under what year could money be collected through the ESM if the company won its petition?
If the company won this petition,
what year could they collect for the ESM?
It would just be collected from this date going forward.
For 1 year?
From when?
From this date going forward, but in the department's position, it wouldn't be for 1 year because it would be implemented as a base rate change because they cannot collect it through the tariff because it's not identified in the tariff, and those types of items cannot be collected.
Well, what year would the base rate begin?
The base rates began in 2009.
Okay. Could the ESM have been collected before 2009 and then stopped at that point?
No, the department's position is the ESM simply cannot be recovered as a discrete amount because what that would be doing is giving them a return on equity retroactively based on the actual costs that they incurred in the past.
Why would this agreement talk in 211 of if it falls below the thresholds in 210, you can file a distribution rate base rate case? It doesn't use that language in 210, but you're saying it would have to be a base rate case.
By its nature, it would have to be base rate case.
Well, why would you use it in one paragraph, not the other, and then you tell me, but you really meant the other?
Because 211 is talking about a full-fledged base rate proceeding, as that term is understood in the industry. So they're talking about a base rate proceeding under Section 94. There's really no other way to refer to it. So it's, I admit,
but what is it under 210?
Admittedly, it would be a lot clearer if it was in 210.
Wouldn't it be under 94 and 210 as well?
It wouldn't, Your Honor. It would be changes to the base rates, but it would be based on the ESM formula. It wouldn't be a full-fledged base rate proceeding, which is why it would be much faster. A base rate proceeding takes 6 months. You have to go through, look at the company's entire financial condition over the test year.
None of which is in this contract.
I'm sorry?
None of which is in this contract. I just read the words. Right? I just have to read the words.
The words of 210 say it's made through distribution rate adjustments, which can include base rates or the LDAF. The company conceded below that it's ambiguous as to how it's supposed to be collected. And my position is that at the time that the contract was entered into, you could only reasonably assume that this has to be prospective, because otherwise it would be making them retroactively whole. And the court has said many times that the ratepayers can't guarantee a company's success.
They're certainly not going to be made whole. Right?
They're not being made whole, but they're being given the opportunity to earn a fair return going forward, which is all that rate making requires.
Now, just help me with one thing. When I read 210, I read it and obtained an understanding that this calculation that would take place under the ESM would take place annually, and it would only apply for the year 2007 and would only apply for the year 2008. And then thereafter, it just dropped off the face of the earth. Is that wrong?
That's
and if it
wrong,
is,
Your Honor.
Now, why is that wrong?
So under the department's interpretation, what happens is if you file...
Show me the language.
Well, it's the department's interpretation of the language.
If you file for an ESM adjustment, the department will take the difference, the deficiency. Say the company's ROE was 7%, so it would see what's required to take it up to 8%. That would be cut in half, shared 50-50.
Now, I forget the math. It's the ESM concept itself. I understood Section 210 to describe something called an ESM that would be applied annually.
It's implemented in the following year as a base rate adjustment, and then that stays in place until the company files either for a new ESM adjustment or for a new base rate proceeding.
So it doesn't drop back to what it was before?
It doesn't, Your Honor, and the reason why that makes sense is
It does or
because
doesn't?
it does not drop back the following year. It stays in place until a new base rate proceeding is filed. And the reason why that makes sense is because just as a base rate proceeding is seeking to predict future costs and revenue based on the test year, the ESM is doing it in a much rougher form. It's representative of what's going to happen in the future. So you make these adjustments, you keep them in place, saying this will be adequate to provide you with revenue prospectively until you come in and file for new base rates.
Thank you, Ms.
Thank
Shannon.
you.